day and welcome to Mining Review Africa at Mining Indaba 2025. I'm chatting to Nicholas Kuria, Counsel at Conyers. Nicholas, welcome.
Thank you.
What does it mean for the British Virgin Islands to be a tax-neutral jurisdiction?
Well, first of all, I'm glad you used the term tax-neutral and not tax haven, so we're off to a good start. That essentially means that a BVI company is not subject to any corporate taxation on income, capital gains, or share transfers. So BVI companies under BVI law are exempt from payment of corporation tax. There's no wealth tax, any capital gains tax, or any tax of that nature on a BVI company's operations in the BVI. Similarly, BVI companies are exempt from statute, under statute from payment of income tax. And the way that the BVI government would raise revenue is actually through imposing pretty modest payroll tax on individuals who live and work in the BVI, on real estate taxes, import duties, and specifically in relation to corporate vehicles through payment of an annual license fee and incorporation fees for BVI companies. So that's generally what we mean when we talk about a tax-neutral jurisdiction.
Why are BVI companies often chosen for international joint ventures or as a holding structure?
I think people use offshore and BVI in particular for two reasons, mainly. It's rule of law, I would say, is the first, and for neutrality. So we can talk about rule of law first. And this is essentially the confidence that the law as written down will be enforced. So if you're operating in a jurisdiction like the US or the UK, this is perhaps not a major concern for you. But for people who are operating in other jurisdictions, for a lot of people in several jurisdictions around the world, that's simply not the case. So they don't have the confidence that they don't have that certainty as to rule of law in their home jurisdiction. So where the BVI comes in is that it provides that certainty, allows people to structure their affairs in a secure, neutral, and stable environment, somewhat protected from the confiscatory nature of their home governments. And then the second aspect is neutrality, which can seem like a sort of loaded term, so perhaps best thought of by way of example. So we are involved in a large number of cross-border joint ventures. And the question always comes up as to how do you structure the joint venture vehicle. So you could use a company in country A, for example, but there may be concerns about the level of corporate governance and transparency in that jurisdiction. And let's say your joint venture partner is the US, for example, in the US. Your other partner may not want to be exposed to the US legal system. So it's in that scenario that the BVI provides a typical third option in that jurisdiction, because in any event, either jurisdiction provides the relevant party with home field advantage. So neither jurisdiction would be neutral from the other side's perspective. So the BVI is a very typical solution in that sort of scenario. And it allows for a third jurisdiction in which neither of those two parties will have any particular influence or insights. So, and it's one in which they can get comfortable because the BVI has been used in global transactions for several years. So people can get comfortable with that. So that's a sort of commercial neutrality that we talk about. And as we mentioned at the start, there is also the tax neutrality. So if you have a joint venture where the operating company is, say, in China somewhere, the local company will be paying taxes in China as it should. And the shareholders of the BVI company will be paying their taxes wherever they're tax resident. What the parties don't need to worry about is planning for taxation in a third jurisdiction like the BVI. So because of the tax neutrality, it takes away that sort of concern.
Yeah.
So that's how the BVI has been packaged and very successfully is marketed to parties around the world. And we see it frequently used on sort of cross-border joint venture work.
What are the most common misconceptions about the British Virgin Islands as an offshore jurisdiction, and how does the jurisdiction counter these myths?
I would say that, I suppose, the first is to do with the tax neutrality, I suppose, that we're talking about. I think there's been a misunderstanding fundamentally about what that means. And it is sometimes taken to mean a jurisdiction in which people can conceal assets and income from tax authorities in other countries, which is simply not the case. The BVI has implemented a regime for the sharing of tax information globally. The International Tax Authority of the BVI was established back in 2018, and one of its key functions is monitoring the BVI's compliance with international obligations in relation to sharing of tax information. So that's been in place for a while. The BVI was one of the first countries to adopt the Common Reporting Standard, so the CRS. And what that is essentially a global standard that was adopted by and developed by the OECD for sharing of information in tax affairs on a cross-border basis. So the regime essentially means for the BVI as a jurisdiction that the BVI is required to collect financial accounts information from its financial institutions and share those with partner jurisdictions on an annual basis on an automatic transfer of information framework. We also have, as a jurisdiction, we're an international financial center, and part of that model is essentially tax transparency, although that's probably contrary to the sort of popular narrative. So the BVI has a large number of, over 100 tax information exchange agreements. And what those are essentially bilateral agreements between two jurisdictions that establish that sort of framework for sharing of information between jurisdictions. So we have over 100 of those agreements in place at the moment. And at present count, there's over 1,000 information requests that have been fulfilled by the BVI. So that is one of the pillars of our model and our business model, but that seldom gets talked about. I suppose the other aspect is the sort of view of BVI as a jurisdiction where there's almost zero sort of regulatory oversight. And again, that's just simply not true. We've had in place for a number of years a regime to deal with sort of anti-money laundering and terrorist financing. So the idea that people can just walk in and just set up companies and move assets and income in and out of the jurisdiction without any oversight, that doesn't reflect the position on the ground and the reality of it. So we've had in place anti-money laundering regulations and anti-terrorist financing code of practice for a good number of years. And we think that's been working quite well in terms of the legal framework. And I think that just doesn't get highlighted enough in sort of the popular narrative about BVI. I mean, to set up a company in the BVI, you're required to do it via a registered agent, and that's a licensed entity in the BVI. So not just anybody can do it. And the registered agents are subject to regulatory obligations under law with respect to anti-money laundering obligations. So that will include collecting customer due diligence information. And failure to comply with that is actually a criminal offense and will attract severe penalties and fines. So that framework has been in place for quite a period of time. I think those are the sort of two main misconceptions that we come across frequently when it comes to the BVI.
Okay. Is it beneficial ownership information of a BVI company publicly available?
So BVI companies have had an obligation to file beneficial ownership information for a good number of years now. And what's happened more recently is that, indeed only about a month ago, there's been changes to the law, whereas previously the regime was that you filed your beneficial ownership information with the International Tax Authority through a system called the BOSS system, the Beneficial Ownership Secure Search System. But the recent change is that information is now filed with the BVI Registrar of Companies, which is like our company's registry. And, the upshot is that the information still isn't publicly available. It's not open to the general public to come and scrutinize the information. But the information has been for a long time and will continue to be available to law enforcement and regulatory authorities in other jurisdictions through formal requests, and there's a framework for that in place. One of the other changes is that previously the threshold that was applied was 25%, so ownership information in relation to 25% of the votes or shares of a BVI company. That's now been reduced to 10% going forward. And so for companies that are already in existence, as at January of this year, they have until the 1st of July to file that information with the BVI registry. And for companies going forward that are incorporated, you have to provide information within 30 days of incorporation. And then on an ongoing basis, as that information changes, you're required to file that information within 30 days with the registry.
Cool.
Yeah.
Thank you so much for joining us, Nick.
No problem. Thank you.